Good day and welcome to GOT Transition's fourth quarterly webinar, Understanding Guardianship and Alternatives for Decision-Making Support. I'm Ann Walls, the Project Manager for the National Healthcare Transition Center, GOT Transition. As you see from this slide, joining me today from the National Center is Dr. Carl Cooley, who will shortly say a few words as an introduction to our topic today. We are pleased to have Tina Campanella from Quality Trust as our guest speaker. In a minute, I will review today's agenda, then introduce our speakers. But first, a little information about GOT Transition and our webinars. We are grateful that our National Center is funded by a cooperative agreement between the United States Maternal and Child Health Bureau and the Center for Medical Home Improvement, GOT Transition's home base. As a National Center, we sponsor these quarterly webinars on topics pertaining to youth and young adults' healthcare transition from a pediatric to an adult model of care. Today's topic about guardianship and decision-making support is apparently of great interest to a wide number of people because we have over 900 registered, and we're very excited about that. We do know that busy schedules don't allow all to join our scheduled webinars, so we do record all the broadcasts and retain them on our www.gottransition website so that those unable to join us live may view them from there. Please do pass this opportunity on, as well as our website address, to your colleagues and friends. We appreciate you responding to an evaluation that you will receive at the conclusion of today's broadcast. A few housekeeping notes about today's webinar. All participants except speakers are on mute, and there will be a 15-minute question and discussion period after our guest speaker has presented. If you wish to submit a question, and we encourage people to do so, please do so in the question box of your screen. You can do this any time during the presentation, but we'll hold all questions until the appointed time of our agenda. At that time, I will read as many of the questions as possible and solicit responses from our speakers. Those questions we may not get to will be compiled in a question and answer format and posted on our website within a week. So for those of you who are not familiar with GOT Transition, we welcome you to visit our website to learn more about our aims and initiatives. In brief, our goal is to support improved healthcare transitions from a pediatric to an adult model of care. We're addressing this need on behalf of youth and young adults with or without special healthcare needs. And in an effort to realize the best processes and approaches to practice-based transition system improvements, we are working with quality improvement learning collaboratives made up of pediatric and adult provider sites in Washington, D.C., Boston, and New Hampshire. Carl will speak more of these initiatives in the context of today's webinar topic. So this is our agenda today. Carl will speak briefly before turning the discussion over to Tina. Following both presentations, we will take your questions and comments for discussion as you present them to us in the question box of your panel. After this segment and in conclusion, I will be sharing resources related to our topic as well as upcoming events that GOT Transition has planned. And now let me introduce you to Carl. Dr. Carl Cooley is the Medical Director and Co-Director of GOT Transition and is the co-author of the Clinical Report on Healthcare Transition. He is a Medical Director of the Center for Medical Home Improvement. Carl?
Yes, thank you very much, and I want to thank all of you listening and watching the webinar for joining us today on your busy afternoons. I think the interest in this topic is reflected in the number of you who are joining us. I also want to thank Tina Campanella for taking the time to present to us. This topic was among the physician practices that we're working with in our 4 learning collaboratives was the first specific topical area that there was interest in having more information, and Tina in fact presented to our Washington group on one of their monthly action period calls last summer on guardianship and models of decision-making support. I want to remind you all, some of you may have joined us in the past, but our work with primary care practices is built around what we're referring to as the 6 core elements of healthcare transition. We feel that if practice settings and clinics can put structures and processes in place that address these 6 areas, that they will have improved their approach to healthcare transition immensely. We feel practices need to have a written policy or approach to how they address the healthcare transition of youth, and on the adult side, how they receive young adults into their practice, that they need to be able to identify and track these individuals to be sure they're getting the support they need, that they need to engage in a process of readiness assessment and preparation for the transition, and that this process actually is likely to continue into young adulthood to some degree, so that adult practice settings need to be approaching this as well. Obviously, planning is important for any complex task, and transition planning needs to begin early and become a incremental process through the adolescent years, culminating but not ending necessarily in the transition to an adult model of care and or the transfer to an adult healthcare setting. And finally, like other processes of life, this particular transition and the transfer of healthcare from pediatric to adult settings needs closure at some point once it is completed. The next slide, please. As you know, we've got learning collaboratives underway in 4 locations. We're about to add 2 more learning communities in Pennsylvania and Minnesota. We look forward to other groups making use of our tools, the 6 core elements and the Healthcare Transition Index, for similar quality improvement endeavors elsewhere. We found that practice teams needed information on guardianship, that they had relatively little knowledge generally about the details of this process. It's an important part of planning prior to age 18 for those individuals where complete independence as a young adult or complete independent decision making will be difficult. And it's important to communicate the decision support plan as part of the information package during transfers of care. Then, as I think you'll hear from Tina, there's a need to follow the safest, but at the same time the least restrictive approach, so that although we've used guardianship in our title, it may not be the least restrictive approach to decision-making support. So with that, I think that's my last slide. Anne, is that right?
Thanks, Carl. Our featured speaker today is Tina Campanella. Tina is the Executive Director of Quality Trust for Individuals with Disabilities. She has led that organization in this role since its inception in 2002. Quality Trust is an advocacy organization located in Washington, D.C., leading efforts to improve community systems and supports for D.C. residents with intellectual disabilities and their families. Tina has over 35 years of experience working with and on behalf of children and adults with disabilities. She has directed residential and employment services and worked as an expert consultant regarding quality improvement and organizational development strategies for human service agencies throughout the U.S. and abroad. In a recent chat I had with Tina as we were preparing for this webinar, she shared her perspective with me that there's a significant need for more education and a deeper understanding about the guardianship and alternatives to decision-making support as they impact individuals with disabilities. As such, we're really pleased to have Tina's expertise today, and as she shares her extensive knowledge about and experience with this topic. Welcome, Tina.
Thank you, Anne. I'm very happy to be here, and I want to start off by also thanking you at Got Transition for this invitation, as well as thanking everybody who has signed up for this this webinar. It's really good to have this conversation, even though in 30 minutes I think we'll probably just be beginning it. It's a conversation that obviously I see as very important and that my organization's been working on for over 10 years now. It's not easy to address questions of capacity for decision making, and our experience has shown that not having access to basic information about how the law works in general and how different options might be available often makes the discussion even more difficult. So my goal for this session is to present and clarify basic information that anyone supporting youth or adults with disabilities need to know about the process and about how to support people, with special attention to ways to support people to build decision-making capacity over time. I also thought it was important to say up front that I am not a lawyer, so you're getting this information from the perspective of a professional supporting people with disabilities. I also think it's very important as professionals that we work closely with lawyers to make sure that we identify and correctly use the best support options available for the people that we come in contact with. Next slide, Ann. So let's start at the very beginning. When thinking about what is guardianship, I think that it's most important to emphasize that for someone over the age of 18, guardianship can only occur as a result of a formal legal process that will involve a court proceeding. The reason I start with that is because many parents, we find, think that because their child has a disability that guardianship is more of an assumed process, that their disability and their perhaps lack of experience with decision making prior to the age of 18 will automatically transfer to parents. So it's really important that that's where we start. But then moving on, it's really also important that the process, while it varies somewhat in different jurisdictions, its general framework is the same from place to place, and that is that the court is petitioned to make a decision about a person's capacity to make decisions for themselves. And then it's determined that the person cannot, so that the court actually assumes responsibility for the person. So the basic premise of guardianship is that you're replacing the court is assuming responsibility and really acting in the person, in place of the person around decision making. So the guardian is an agent of the court, and as the court's agent, they must act within the guidelines of the law. So there are certain parameters that will be placed, it will be described in law that the guardian must follow. But it's basically a significant decision because even though it can be reversed, and in certain situations, certainly we've been able to make the case to courts here in the district that circumstances have changed for a person, it's typically very hard because as you can imagine, as courts go through a lengthy process to make a decision as significant as limiting a person's ability to make decisions for themselves, reversing that decision will be equally done in an equally careful way. So I think when you think about guardianship, we really need to think about pursuing it because we're fairly confident that that is the actual solution that we see as the best fit for the person. Next. So thinking about within that definition of guardianship, you want to next think about what guardianship does and the impact of guardianship on an adult. And you can better understand, if you look at it from that perspective, why it's considered the most restrictive option. So a guardianship, basically it has this decision that says the person is incapacitated. It assigns some or all decision making to an agent of the court, and then it really places, based on that decision, restrictions around a person's rights and freedoms. So certain things they don't get to do unless the guardian supports them in doing that. So there are very direct and indirect consequences from the perspective of a person with a disability. The very direct one, obviously, is whatever limitations get placed on the person depending on the type of guardianship and the scope of the guardian's decision-making authority. So it could be fairly limited. We have a number of people here in the District of Columbia, for example, who have limited guardians for health care. So that really the limitation that is placed on people is that when there comes to a decision about certain medical treatments, certainly the more invasive treatments that typically require more in-depth consent, we look to the guardian to make those decisions. Now that can, and we'll talk about this a little bit later, that can cause some friction between the person and the guardian, but by using a limited guardian, you can kind of limit some of those impacts. The more difficult impact of a guardianship, I think, very often is presented by this whole stigma and image that's presented by a person being determined to be incapacitated, and the idea that because of that incapacitation they need supervision by an external party. And I think what we've seen in that situation is that you see the person's authority being eroded, or the respect for their independence and authority not being as broad-based as it would be if they didn't have this guardian. Now, this is probably easiest to understand if you think about it in the context of somebody who's aging. So many times, for example, you might see family members seek guardianship for an aging parent because they're worried about diminished capacity and the potential for exploitation and harm. That can be a very productive approach depending on how the guardian handles it and the guardian's attention to including their parent in the decision-making process over time. However, too often we see that once the court has granted guardianship authority to a family member, decisions are made without consulting the person for whom the decision's made. And in fact, even though there are some preferences, those not being reflected in the decision-making. So you can imagine the impact it has for an older adult. It can have the same impact for a younger adult with disabilities that's just transitioning into adulthood by shutting off a whole world of opportunity for them to learn, to make decisions, and to gain from real-life experience through decision-making. Next slide. Okay, so why families seek guardianship? I think there are many reasons that we see, but some of the reasons really link, I think, back to this whole notion that it's really seen as the only viable legal solution. So we'll really want to emphasize the options and how to make those options real for families as we go through this. I also understand that there's significant concern about access to school or health records after a young person turns 18. There are often very simple solutions that can be used to address concerns such as that. And I think the point really that we need to keep in mind when we think about helping families to think through whether or not guardianship or another alternative is the best fit is to help them really understand all the options and the needs of their child and how they best can be addressed by the different options that are available. Next slide. So, the important things to remember as we address decision-making for the young adults that we work with. First of all is this presumption of capacity. The law presumes capacity, and people cannot be deemed to lack capacity based solely on their diagnosis. So the whole notion that folks should be presumed to be able to learn decision-making over time is really a critical thing to keep in mind. And my second point here about decision making being a learned skill is also very critical, because if you think about the whole period of young adulthood for most people, that really starts in mid to late teens and then carries on through their 20s for most people. That whole process of making decisions, sometimes really bad ones, and then learning from that life experience is all part of how we build decision-making skills over time. So the opportunity for learning has got to be seen as just as critical, if not more critical, for kids with disabilities if they're going to be participants in their own life decision-making process. I would also note here that even if a person has an appointed guardian, this is a critical skill, and it's a critical thing to keep in mind, because even with a guardian, best practice really dictates that the guardian take into consideration the person's preferences and wishes as they make the decision. Again, we'll talk a little bit about this a little bit later as we talk about expectations for acting as a guardian. But let's talk about alternatives. So next slide. So let's think about the available alternatives and how we might approach them. In this slide, what I was trying to do is give you some framework to think about how you weigh out different situations before you pick out a solution. Because all the solutions are good solutions, but we've got to figure out how to make them fit with the actual decision and person that we're working with. So the kinds of questions I've got here are really helping you think about what's the level of impact for this decision. Is it a new decision for the person? Can the person be assisted to understand aspects of this decision that will help them express their preferences? Many times the people that we work with, and that would be defined as people who have primarily intellectual, but a lot of people with other sort of developmental disabilities that are not primarily developmental. It is really helping them to translate the situation in terms that they can understand given their limited life experience. And for some people that limited life experience is because they're young, but for many of the people we support who are already adults, the limitations in their life experience really relate to them having been institutionalized or been in situations where they've really not been asked to make decisions in certain areas before. So for example, I can give you a very practical example. When we first started working on this issue, many of the people that got referred to Quality Trust for support were people for whom there were questions about them being able to give consent for a colonoscopy. And one of the things that I personally did was to go out and meet people, because people were really making the decision based on the presence of a diagnosis and not necessarily evaluating for people. And what I found is that many people could understand the situation and give consent without any real difficulty. For other people, it was very hard to understand what their preferences would be. So you could see where somebody who knew the person a lot better than I did, since I was just meeting for the first time, should be involved in helping them to make that decision. And because they've never made it before, and their means of communication is very difficult for anybody who doesn't know them really well to understand. And we can use that information to really help us figure out what is the right support that will place the least restriction on the person. Again, sticking with the colonoscopy example, and we can talk about how big is the impact of this decision on the person's life. for some decisions, like a colonoscopy, the impact, while there are clearly risks, is not necessarily life-defining. For other decisions, and we've had people come to us, again, who, based on their preferences, are actually making decisions to refuse treatment that could lead to the end of life. That's a big decision. That's a huge impact. Now, it doesn't mean because the impact's big that we don't let the person make the decision. It does, however, mean that the bigger the impact, the more certain we want to be that the person can demonstrate some ability and some capacity to take in information, process that information, and then communicate clearly what their preferences are. Okay. Again, how long would they have to live with the decision is an impact here that we're asking, and how hard would it be to undo the decision, is we're asking you to think about, is the decision the person's being asked to make something that could change the course of their life. Again, there are a few life decisions like that, but they tend to be a smaller number of choices that we get to make. So the most restrictive form of decision-making, support, i.e. guardianship, is really only needed for the most important and most impactful types of decisions. Okay. Next slide. Okay, so let's look at some of these alternatives and talk about how we might use them. First, and the least involved, are informal supports. And when you think about informal supports, you're really just talking about friends, family, people who know the person well, people who are familiar with their communication style. If the decision being made is something that can be assisted by the person with, that know the people well, then that's the least intrusive and most typical, if you think about it, type of support. Because although we talk about ourselves as being independent decision makers, we often don't make decisions totally on our own. And in fact, the more important the decision, the more likely we are to spend a lot of time talking it through with a lot of people we know really well and trust. Again, if you're talking about decisions about how people handle their money, there are tools like joint banking accounts or trust accounts or direct deposit, or now that we all have all these credit cards and debit cards, those are tools that can be used to help provide some controls in people's lives, but also to enable people to be active participants in the decision making. And they're decisions, of course, that the person can participate in. So for example, the person can actively agree that somebody be involved with them around making their money decisions. If the person actively agrees, obviously, they can actively withdraw that agreement. And that's what we like about those sorts of arrangements, is because it really puts the person in some decision-making role, even if that decision-making role is simply indicating who it is and how it is that person will provide them with some assistance. With health care, we have some very similar tools that are defined by laws across the country that are commonly referred to as health care decisions laws, which really pull on the first two things. It really it says, first of all, if the person has the ability to indicate that someone, that they want someone to help them with the decision, then they can do that, and they can execute a durable power of attorney for health care that gives that person the authority to help them with decisions if they should need help making health care giving consent or making any complicated healthcare decisions. The Healthcare Decisions Act is another tool that says if the person is deemed to be incapacitated in any kind of emergency situation, it typically gives a list of people who are very often family, friends, spouse, people in their that know the person well is the best probably way to describe what kind of joins that person together, that group list of people together. But it gives them the authority, or gives healthcare professionals actually the authority to pull on one or more of those people from that list to make the decision in that situation on behalf of the person. And then the last option that I would separate from guardianship, but obviously it's court involved, so it's under the heading of guardianship, is a guardianship, but one that is limited in scope. So it's limited only to whatever area the person might need decision-making support in. Next slide. Okay, so again, we've talked about decision-making support, but I also felt in covering some basic territory here that it was really important for us to spend a few minutes talking about capacity so that we could think through some basic principles around what is capacity. Because there is no test for capacity, and capacity is incredibly challenging to assess and measure. One of the things we did at Quality Trust when we first started to address this whole issue of decision-making support is to look for assessments that folks were using around the country. And what we found is that there were several projects working to develop tools, but for the most part, people were using all kinds of different tools to determine whether a person did or did not have capacity. Some people relied on IQ tests and other formalized testing. But many decisions about capacity that were made by professionals were made based on judgments. So, we believe it's very important to keep in mind that capacity must be understood in context, and that capacity may change over time or in different situations. So if you think about capacity is as my familiarity with the situation, again, my ability to take information in, which again may be impacted by my familiarity with the situation or the activity, and then to process that information and then come out with what I believe is my decision relative to a given situation. That may change over time as our skills change. One of the most practical examples I can think of for people to really put this in their own life context is have people to think about the first time you bought a car, and a new car in particular. Major purchases like a car or home are complicated. Most of us probably can relate to the feeling of not having the skills, information, experience, or support needed to make a good decision like that the first time we did it. For me, I was away, I was young, I didn't have any family around, and although I got through the decision-making process with an okay outcome, I didn't feel very confident that I had really good capacity in that area. Again, I would say we find ourselves in those same situations very often when we're facing difficult healthcare decisions. So if, I'm talking about a decision to have a routine test, the first time I have it, it may be scary. The next time I have it, it may not be so scary. I may feel I'm a lot more confident now that I've had my first colonoscopy about what that test entails and the risks associated with it than I was the first time. But given I've been making healthcare decisions all my life, and the impact wasn't terribly huge, I wasn't too terribly intimidated by that decision. However, I will tell you I have had other major healthcare decisions, both for me and my family members, that involve serious and scary impacts where I have felt not well equipped. That capacity that change in capacity is relative often to the situation. Now, it doesn't mean because you don't feel well equipped, you can't get support. Of course, this is where family and friends and other people can really be an important assistance to enable people to make a good decision, or at least to be participants, active participants in the decision-making process. I would underscore on this that lack of opportunity to participate and make decisions can actually be a self-fulfilling prophecy here that is the primary reason that people don't, over time, develop increased capacity for decision-making. So, my message to everyone listening here is that we should think carefully when we talk about capacity and talk about, in particular, people not having capacity, and ask ourselves some hard questions about whether or not we're certain that that capacity is not simply linked to a lack of involvement and experience in prior decisions, and that with support couldn't be changed or improved over time as the person is involved and has the opportunity to make decisions, or at least participate in their own life decisions. Next slide. Again, just to reinforce this, I would say what we need to think about is, when we're often scared when we think about the healthcare decision kind of in the raw form, if you will, and that would be deciding whether or not to have a serious medical treatment done. But a person can be in control of their health care through the use of a healthcare power of attorney that basically says, I know this is a serious decision, and I know I may not be in a situation to weigh all the variables that are important to weigh here, but I'm really confident that if I give this authority, or I designate my mom or my friend or my advocate as this decision maker support, that I can get through it and that my perspective will be respected. Next slide. Coming back to guardianship, I want to emphasize that, again, these different types of guardianship, every state will have different categories or different definitions associated with some of these terms. I know, for example, in some states, the term conservator is actually used for the function of what is typically called guardians in other places. So again, please take the message. You need to consult the actual law in your own state and probably seek legal advice to fully understand all of the elements there. The point here being that it's not a one-size-fits-all, and even if we choose to use the most formal and often permanent type of decision-making support, that we can place limitations on that if the situation does not call for a pervasive or permanent solution. Next slide. Okay. And these are kind of some wrap-up points about guardianship. Even when there is a guardianship, the guardian's authority includes, really, from the best practice standpoint, including the person in the decision-making process and making a decision using a standard for decision-making called substituted judgment that we'll go over in a minute. And ultimately, the guardian is accountable to the court because guardianships are held by the court, and the guardian really is an agent appointed by the court to act on their behalf. So it's not really that a guardianship is given to a parent. A guardianship is taken by a court, and then the court appoints the parent, if they so choose, to act in the role of their agent and to make decisions given the framework of guardian on behalf of the person. That decision can be changed over time should the court not agree with the decisions that the families are making. We've actually counseled many families to really give serious consideration to some of the alternatives because we feel it gives them actually a lot more control and a lot more privacy in their family decision making, working one-on-one with their family member, and actually can result in a better situation in the long run for both parents and their adult children. Next slide. Substituted judgment. Again, we're coming to the end of this, so I won't necessarily be able to give this a lot of attention, but I think it's very important to say that the surrogate is not making the decision that they think should be made for the person. They're really putting themselves in the person's shoes. So they're expected to make the decision that the person would if they could. So to really use the person's values and belief system, their preferences and wishes as a lens through which they're making decision. Many people, when they are implementing a guardianship or acting as a guardian, make a decision based on best interest, which is what they think is the best in the best interest of the person. That really shouldn't be the standard used unless the actual wishes and preferences of the person cannot be discerned. Next slide. So, as beginning here to wrap up, we know that guardianship is not the only option. I would emphasize that guardianship is a tool that we can use to support people, but it's not the only tool. And because it restricts people's rights, it should be used only when we really feel compelled that it's absolutely necessary. We have other tools and options to consider, and it's really critical to engage in a dialogue about how we can do that and still respect the person. Next slide. My final point would be where I started. Again, I really feel that as non-legal professionals in the lives of people with disabilities, we should make ourselves as familiar as possible with the principles of guardianship, how we can support people in capacity and decision making. But in the end, I think we need a partnership with our attorneys, and there are a number of attorneys who have good expertise in this area who we can rely on. We certainly at Quality Trust are happy to share some of our experience and resources, and I know that Anne is going to share some additional things that she found that might be useful for folks as well. So Anne, I guess I'll wrap up here and see if you've got questions.
Thanks so much, Tina. Thanks so much for your comprehensive overview. And I'm happy to say we have a number of great questions that I think is going to further enrich this conversation. So I will just start here with a question from Annie. What are the pros and cons of seeking guardianship before something happens versus taking a wait-and-see approach and seeking guardianship later if the young adult proves unable to handle decision-making?
Great question. Again, I think that as you're planning for transition, it would be perfectly reasonable to discuss putting in place kind of right away a health care power of attorney. It's very interesting that many of us really who don't question our capacity, we know the importance of doing that because, at any point we could be incapacitated. So, when crossing the street or even walking down the sidewalk, something could happen to us. And if we don't have a health care power of attorney in place, then certainly those emergency procedures that I talked about applying for the young adults that we support would come into play. But the process goes a whole lot more smoothly if you have those things in place. So if you could execute a healthcare power of attorney, that could be your safety net to work with that in the interim and see how capacity develops. The con obviously is that while some guardianships can be done on an emergency basis, typically the guardianship process takes time. Because it's a removal of people's rights, the courts like to be careful about this, as they should be. We have had situations where it has caused some delay, but I think there are a variety of tools, and including using healthcare power of attorney as sort of a safety net and a prevention tool that could kind of give you a little sense of safety that there's a backup decision-making process while not actually going for the guardianship right away. So hopefully that answered it.
Thank you. Tina, here's a good question. How early can you start the guardianship procedures?
That's probably a question that is best asked to an attorney in a given locality. Guardianship's not relevant until somebody turns 18, but I would imagine that states have provisions and courts have practices that kind of account for that. But that's definitely a question that I would immediately go to consult with a lawyer on.
And this is kind of a related question. When should parents start thinking about the issue of guardianship?
I would just reframe that a bit and say that I think families should start thinking about the whole process of helping their children learn to become adult decision makers in the teens. So before you get to 18, and as kids begin to age, just as you would a typical kid, I think parents ought to think about including the kids in some decisions that involve their life. So for kids in school, I think they should start attending their IEPs. They should be started to be involved in talking with the doctor about their health and their health care decisions and taking greater control. And that experience pre-18 would give the child and the parent an experience base to really evaluate what sorts of tools are needed post-18. So I really encourage people to think of this as a lifelong learning process, but certainly one of transition to adulthood that begins in the teen years for kids with disabilities, just like it begins for the rest of us, and probably carries on into the 20s, because that's a typical maturation process.
Great, thanks. Jody asks, what's the difference between financial power of attorney and conservator?
Again, in my experience, although I would check this with your own locality, in my experience, a power of attorney is something you execute. You can use an attorney to execute it, but it's a legal document that actually typically doesn't require an attorney. You can usually get forms in bookstores and things like that. But it's a process in which I give authority to somebody for a specific reason, and because I gave it, I can take it away. With a conservator, typically those are appointments that are made through a court process. Again, you need to check with your own local laws to see how that term is applied, but I don't think I've ever run into a situation where a conservator wasn't actually a court appointed. But I would check that.
I just wanted to say that we have several questions coming in here, several really good questions, and I wanted to assure everyone that we may not get to all of them. We likely won't get to all of them, but we post all questions and then answers on our website that you can look at within about a week. So here's a question. If it is for the greater good of the young adult, even though they can voice they do not want you to help them, what should you really do? Can you then have an attorney to help with determining they need help somewhat? That's from Angela. I don't know if you want me to repeat that.
Wow. Well, you know, this is a great question, And it's the toughest of the questions because if I'm understanding what Angela's asking, she's saying, how do you help somebody who doesn't want help? And that's it's a question I encourage people to really think very hard about, because I too often see people saying, I'm trying to help the person, they won't listen to me, so I've got to go get guardianship. I've got to get the court to say I can make the decisions. So you go to court, you get guardianship, and now you have the authority to make decisions, but they still don't want your help. It doesn't solve the problem. So we often deal with people that are very hard to help. Getting guardianship is not going to make them any easier to help. It's just going to give you the authority and responsibility to try and help them, but they've got to deal with the problem of why they don't want help. That's not going to go away until somebody gets through it. And why they don't want help could be almost any reason. So your best bet is to try and figure out what's going on. Sometimes if it's a family involved, it does help to have a third party. It may be that the young adult is feeling like, I want to be more independent, and I don't want to rely always on my mom or my sister or my dad or somebody else. It's too close. So I think we can all imagine situations where we take information in differently from somebody who we're not related to than we do from somebody who we are related to, simply because of our history with that person. I think some of those same principles apply to kids with disabilities equally and just the same as they do to us.
Thanks, Tina. Heather asks, what does it mean to evoke healthcare proxy?
Ooh. Again, where I would go with that question is where the question, in the locale. We don't use the words healthcare proxy in our jurisdiction. So I could imagine it might be a healthcare power of attorney, which is kind of a proxy document where you're giving authority to somebody to help make decisions. But to be certain that that's what it's being referred to, I would check your local regulations and requirements. I would also add to that very often people use words informally. And it's not necessarily helpful to do that. For example, I hear people say all the time that people are their own guardian. Again, people aren't necessarily their own guardian because guardianship is not an issue that's been applied to people. As I said earlier, there's a presumption of competence. And once you have a presumption of competence, we're assumed to be our own decision makers. Okay? Guardian's only a concept when there is other people making decisions in your life and a determination that you do not have the ability to make decision making. So again, I'm not exactly sure how proxy is being used in the context you're asking, but typically my experience with that is it's where you give authority to another person to make decisions or to assist you with decision making.
Thank you. And a question from Leah. What is your advice for families who cannot afford the attorney fees?
Each state and locality is unique, but we often help people find legal services, public legal services, organizations that will help. We've, on behalf of some of the people we represent, have approached our local bar association and asked them if they can locate people in the legal community, lawyers in the legal community, who'd be willing to act in a pro bono way. And then while I'm not necessarily advising it, it is the case that you do not need an attorney to file a petition for guardianship, and many courts, including the courts in the District of Columbia, have instructions and forms online that you can go to and download and complete and file with the court. So I know several people who have actually petitioned for guardianship here in the District of Columbia without the assistance of an attorney. Again, my recommendation would be to seek that assistance, given that if you don't have the legal expertise and background. However, it's not necessarily required.
Thanks, Tina. And I just want to say again, there's many excellent questions have come in, and I'm afraid that we have run out of time for that. But again, we'll be posting the question and answers on our website. You can look for them in about a week. I also want to note that several people sent in comments and also suggestions relative to resources in their area. So speaking of resources, I want to just near the close of this webinar talk about a few. The first one is the organization that Tina is the Executive Director of, Quality Trust for Individuals with Disabilities. Thank you so much for providing that resource for us as a link today. The ARC for people with intellectual and developmental disabilities has several position papers on the issue that would be helpful. And for all of those that are wondering about resources in their own state, both the U.S. Department of Health and Human Services Administration for Children and Families, this link here will get you to a directory where you can find resources in your state, protection and advocacy resources, as well as the National Disability Rights Network. So, and again, we'll be listing any resources that people provided from this webinar. We want to really thank Tina for being with us today. We so appreciate your expertise in sharing your knowledge. In closing, I'd like to just talk about a couple other God Transition events. Some of you may know we have a weekly radio show that is hosted by Mallory Sear, the National Center's Youth Coordinator, and Eileen Forlenza. She's a national family leader, and she's associated with God Transition on our cabinet, and they are the hosts for this radio show. The episode 7 is coming up on March 28th. You can listen live and submit questions such as with this webinar, or you can listen to past episodes by going to our website and downloading broadcasts or iTunes there. And there's a link for where you can find past radio shows and webinars, that link there. You can also follow us on Facebook and Twitter, which we encourage people to do, another way of getting forums and discussions going. And this last slide is a link to our website again, and for anyone that would like to contact me about questions about God Transition or to know about future webinars. In closing, I'd like to say if you are not on our contact list, it's very easy to get connected. You just go onto our website, go to the home page, and click on the e-contact button, and you can sign up very easily. We will be having a release of a brief on guardianship and decision-making support, which will be available on our website, and we'll send out a notice to our contact list when this is available. So again, if you want to hear about this, make sure that you register through our Get eNews. I'm sorry, it's not e-contact, it's Get eNews. So look for that brief. And again, please share the fact that these broadcasts are on our website. We got several questions about that during the question period, and yes, they are. So share that with your colleagues and friends. And I'd like to again thank Tina for being with us and Carl for also the opening remarks. And with that, I will close